Good morning and welcome to Employment Hour in 30 here on Global. Once again, Saturday morning, John Scholes, your host. My co-host, Lior Samfiru from the Samfiru Tumarkin law firm. Lots of stuff to get through today. We'll get to the severance pay calculator. We have your partner, a special guest on the show today as well. EmploymentHourTV.ca online and emails anytime, help@employmenthour.com as well. We start each show, Lior, with the week that was, a case, something that's come across your desk you've been working on recently. Might be of interest, will be of interest to our audience. So what do you got today, pal?
Well, John, we've been doing the show now for a while, and the response has been great. People have been calling, they've been listening. I feel that people are now getting empowered to ask about their legal rights, to find out about their legal rights in the workplace, and that's terrific. That's why you and I are here every week. That's why we do our radio show as well. We want people to feel comfortable knowing that there's help, there's things you can do if your legal rights are contravened. So if you have a problem in the workplace, your boss did something, said something, your terms of employment have been changed, maybe you're mistreated, being harassed, maybe you lost your job, give me a call. Let's talk about that. Let's make sure that you get what you're owed. The law's quite good in protecting employees. And I want to start off, as I do every week, with a matter that came across my desk over the past few days. So this matter that involved a gentleman that called me. He had worked in the plant, and a few weeks ago, his employer came to him and a few other colleagues and said, we need you to work a few extra hours. It's a very busy time, so we need you to put in some extra hours. So him and his colleagues, being good team players, said, no problem. They worked some extra hours, in fact, some 50-hour weeks, and they didn't get paid anything extra. They didn't get paid overtime. They didn't really think about it. They thought, we're going to be good team players. Well, fast forward a couple of weeks later, things are still going the same way. They're still working all these extra hours. So this gentleman goes to his boss and says, well, if I'm going to continue working these crazy hours, I want to get paid overtime. The boss says to him, well, no. That's part of your job. To meet the demands of the business, you have to work as long as it takes. So we're not going to pay you overtime. Well, this gentleman, being, not someone that's going to be taken for a ride, said, no, I am not working unless you pay me overtime. So sure enough, he doesn't work the extra hours, and then he gets let go for insubordination. The company says, you didn't work the hours. We told you that's insubordination. We're letting you go for cause. And of course, this gentleman was upset. He had worked for the company for over 12 years, and he called me. He listened to our show, and he wanted to know what his rights were. Well, here's the thing, John. An employer has to pay overtime. In Ontario, if you work more than 44 hours a week, you have to get time and a half beyond that. The employer can't decide that they're not going to do it, they're going to do it differently, they're going to make exceptions. There's no exceptions. And beyond that, if you try to enforce your rights, if you stand up for your rights and you're let go because of it, that's illegal. That's a reprisal, we call that. You can't be let go for trying to stand up for your legal rights. So not only is it not cause when they let him go, he's owed full severance, and for him, over a year's pay. But the fact that he was trying to stand up for his rights and was let go, that's a reprisal, that's illegal. So I want our viewers to understand that your employer can't punish you because what you're trying to do is stand up for your legal rights. And when it comes to overtime, John, 44 hours a week, anything beyond that, time and a half, and it applies both to hourly employees and salaried employees.
I want to mention this as well. Anytime you need to get hold of Lior or a member of the firm, 1-855-821-5900 is that number. And we usually mention off the top of the show, this is why we do this show, to inform people. If they haven't watched it before, this is your employment rights. It's where you spend, at least 2/3 of your life, 8 hours a day plus, and you should know what you're in for, right?
Most of us spend more time working than we do anything else. And our laws at work are good. And if something goes wrong at work, John, then it's going to impact the rest of our lives. It's a big deal. And so many people think that there's no hope, there's no option, that the law doesn't help them. That's wrong. And we want to educate people right here on this show and on the other shows that you and I do to make sure that people understand that there's things that you can do. It often just starts with a phone call, John.
You said other shows, and what Lior means by that is we do a bunch of shows on Ontario radio stations. EmploymentHour.com. You'll want to go to that website and find out where you can listen to the 1-hour radio show, the Employment Hour, which we get, and we kind of get down here to the nitty-gritty, the Employment Hour in 30, and do some stuff. That week that was scenario, now that's overtime. That's legally mandated. He has to get paid overtime. But if it were something else as far as holidays or a change of shift, Could that have gone on for a certain amount of time and he couldn't do anything about it? Or would he have to nip it in the bud right away?
So generally speaking, if your employer changes the terms of employment and something new, so they've imposed something new, new hours, new compensation scheme, whatnot, and you accept it, you don't do anything about it, then at some point it's going to be too late to do something about it. Usually there's a small window, maybe a couple of weeks. So if your employer changes the terms of employment, you have to do something about it now. Don't wait, because if you wait, you're going to call me later, we had a phone call. Someone said that 4 years ago my employer changed the terms of my employment. Well, it's too late now. You've accepted those things. So you have to act as soon as something happens.
You mentioned phone call again. 1-855-821-5900 is the number. EmploymentHour.com. As I just mentioned, we do a radio show. Been doing that for what, 4.5 years?
A long time.
And you want to go to that website, find out where and how you can listen to that show, and we'll get a phone call from the show from a previous one.
I've been with a company between 20 to 30 years. I'm in my mid-50s. I can kind of feel the being pushed out the door. My emails are not being answered. My phone calls are not being answered. Now they're talking about outsourcing the program itself. And now there's another thing I forgot to tell you. When I started, they asked us to open up a small company. But if they pay my company, they don't pay my vacation pay. They don't pay my holidays.
Yeah.
It sounds like they're calling him an independent.
Well, they're calling him an independent contractor, and I want to talk about that. But first of all, I'll say this. If your spidey sense is telling you that you're going to be let go, most of the time that's right. Yeah, trust that sense. I've gotten a lot of calls over the years from people saying, yeah, I'm not getting my emails returned. They're excluding me from meetings. I think something's coming down the pike. And yeah, sure enough, that's a termination. So yeah, it's quite likely that this gentleman may actually have his employment terminated. Nothing that can be done about the termination itself. But if he's been there for 20 to 30 years, he would likely be looking at as much as 2 years worth of severance.
Well, 55, I think.
Yeah,
right?
in his 50s, 20 to 30 years, that's 2 years of severance. Now, the interesting part that you picked up on correctly, John, is they appear to be treating him as an independent contractor. I can assure you, after 20 to 30 years working there, there's no way he's an independent contractor. He's an employee. And it's important to understand that it doesn't matter if your employer pays a company that you have or if they don't withhold taxes. The law decides whether you're an employee or an independent contractor. If you work consistently and regularly for a company, you're likely to be an not an independent contractor. You're going to be an employee, which means you have the same rights as an employee, especially when it comes to termination of employment. So he really does need to call me when employment comes to an end. He's going to be out as much as 2 years severance. And our viewers should know that calling yourself an independent contractor does not actually make you an independent contractor.
You know, some of our viewers are probably saying, it kind of sounds like me, but it doesn't sound like me. Is there something between an employee and an independent contractor? Can you go halfway?
You can go halfway. Yeah. What we call a dependent contractor. A dependent contractor is someone that's not quite an employee. He doesn't work exclusively for a company, but that individual is still financially dependent on one company to pay them to pay the money. So if you're a dependent contractor in between an employee and an independent contractor, you still get severance if you are let go. So even in situations where you're not an employee, you're something other than an employee, you may be owed severance, full severance, which could be, as we said before, as much as 2 years' pay. That's why it's so important. If you lose your job, if you lose a client, even in some situations, you have to give me a call. Let's talk about what you're owed. Let's make sure that you get what you're owed. Every day, people walk away from all their entitlements because they don't know any better. So if you're watching us right now, don't let that happen to you.
You use the example of a plumber, right? A plumber comes to your house, but he's not your employee, obviously.
No.
He does his job and he gets out of there.
So the plumber is not owed severance if you decide to hire a different plumber, right? But on the other hand, if the plumber was at your house every day doing work and for years, then guess what? If you decided after that period of time to tell the plumber to stop coming in, then yeah, you would owe them severance. So it really comes down to the nature of the relationship, not the title that's put on it.
Help at EmploymentHour.com is the email, and 1-855-821-5900. Anytime you want to get a hold of a member of Lior's team or Lior himself at the firm. We'll get to a note here from Frank. Says Frank has worked at a roofing company for 12 years. They just fired him, citing slow business, but gave him no severance pay. Are the rules different for roofers?
Well, the rules,
or I guess construction industry for that matter.
Well, the rules are not really different. Now, if he's laid off in the winter every year, gets called back in the spring or summer, and that's the way it's been, then that's okay. But if he's been there for 12 years, never been laid off because of slow business, and this year he is all of a sudden, that's not legal. That's a termination. That's a constructive dismissal. So, and the same rights apply. If you're in a seasonal business, then it has to be seasonal always. It can't just be seasonal this year. So if you're a roofer and you always have a job, but this year the company says, no, we don't have a job for you now in the winter, so we're going to call you back in a few months, they don't have a right to do that. That's a termination. So the same thing applies to anyone, by the way, in the construction industry. A lot of people think that people in construction don't get severance. Wrong. You get the same amount of severance if you're in construction as every other employee. That's why it's so important to give me a call if and when position comes to an end.
If you're a roofer or in construction or that business, how many times can you go through that cycle where you can no longer say, okay, now it's an implied term of your contract or your job, and you can't get severance if you.
You know, usually one time may be enough. So if you allow the company to lay you off one time, they have the right to do it again and again. So that first time that it happens, unless it's something that you expected and they told you in advance when you started that it's going to happen, you have to act as soon as that happens.
We'll take a short break here. We'll get to the severance pay calculator. I mentioned that off the top of the show. It's a very important thing to check out. You can do it at home and follow along as we do that. Failed accommodation and long-term disability as well. It is help@employmenthour.com. And if you want to check out the show anytime, employmenthourtv.ca as well. Take a short break. We'll be right back.
Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact, over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 9.
I can just call the labor board instead of a lawyer.
Fact, the labor board cannot help an employee get their full entitlements. Always go to employmentlawyer.ca and check with the employment lawyer first.
EmploymentHourTV.ca or help@employmenthour.com or 1-855-821-5900 anytime to get a hold of Lior or a member of the team. We mentioned it before we went to break. Want to get right back into it. SeverancePayCalculator.com. It's easy to use. You made this thing about 4 years ago. What is it and how does it work?
Well, John, probably the most common question that I get in my practice is how much severance am I owed? I lost my job. What do they have to pay me? Or is my severance offer fair? So I wanted to make that information available to everyone in case you don't want to call me or it's the weekend and I'm not available. You need to know how much you're owed. So I created the Severance Calculator. It's a free online tool. It's available at SeverancePayCalculator.com. And when you go to SeverancePayCalculator.com, you're going to be asked 3 simple questions: the length of your employment, your age, and the type of job that you have. Well, you answer those questions and you're done. You find out exactly how much severance you're owed. It's free. It's easy to use. It's anonymous. There's no strings attached. You have to make it the very first place you go to if you lost your job, John. It's such an important tool. Thousands of people have used it, and by using it, they were informed. They did not accept inadequate severance, and maybe you're just curious. Maybe you're not losing your job, but you always wanted to know. Well, check it out. Be ready. SeverancePayCalculator.com.
The first timer is going to try it and say, okay, I got my severance offer here, says I'm owed 2 weeks. Your calculator says 7 months. Is this thing accurate?
It is accurate, John. It's completely accurate. And most people have exactly that reaction because they don't know any better and they assume things that are wrong. So with that in mind, let's run through a real example on the severance calculator. This is from a matter that came across my desk a few days ago. So this gentleman had worked for a company for 20 years as an electrician. He's 52 years old. He made a salary just under $60,000. When he was let go, he was offered 6 months severance. Now, I used the calculator, and the calculator correctly assessed him as being owed anywhere from 18 to 24 months severance. Now, the difference for this gentleman is somewhere between $60,000 to $90,000, the difference in the extra severance that he's owed. So do you think, John, this is a gentleman that's happy that he used the severance calculator?
Yeah.
Unbelievable, right?
And it's just a couple clicks and he's there, right?
It's so easy to use, so don't let that happen to you. If you're going to be looking at a severance, if you're going to have a severance offer in front of you, please, please, please check yourself. Don't accept that, even if you think it's good. SeverancePayCalculator.com.
EmploymentHour.com. You want to check out a variety of radio shows you can find in Ontario that we've been doing for over 4 years now. We take phone calls all the time. 1-855-821-5900 is the number. Let's get to a call that we got from that show a short time ago.
I've been doing the job for 17 years, been on the same shift for 9 years. I have a sick father and a sick brother that I take care of every day. My job starts at 5:30 in the morning. I'm off at approximately 2, and they want to change my hours. They've come up with solutions, but those solutions just won't work because I live farther away. Can't happen. So I'm just wondering what my rights are there.
I'm smelling accommodation. right?
You're learning. After all these years, finally, John's picking up something. Well done, John. Well, this is actually, believe it or not, a common situation. I get calls like this all the time. And you're right, this is a matter of accommodation. A company has a duty to accommodate based on what we call family status. So if there's a family situation that you have to take care of, and the only way you can do that is by getting help and flexibility from your employer, then the company has to provide that accommodation. That may mean different shifts, shorter shifts, changing some of the schedule around to allow you to do that. So the company cannot say, too bad, we won't do it, that's your problem. If you need help because of a family situation, the company under the Human Rights Code is obligated to accommodate. If they don't, that's a human rights violation, that's illegal. That can even be a constructive dismissal. Certainly, if that happens, you know what to do. You give me a call.
And that number, 1-855-821-5900. It is help@employmenthour.com. We're going to take a short break. For the first time, again, very important segment coming up. Your firm has the unique combination of doing both employment law and insurance and injury law. Your partner, Sivan Tumarkin, will be on the show when we come back from that short break. Hang on.
Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact, in most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first.
You know someone that's been let go. Tell them to go to severancepaycalculator.com. You have the right to have that information. It's not what the employer wants to pay you. It's how much you're actually owed. And the place to go to, severancepaycalculator.com.
Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com.
Welcome back to Employment Hour in 30 and 1-855-821-5900, the number anytime to get a hold of Sivan or Lior, your partner here at the firm. It is help@employmenthour.com through emails as well. So as mentioned, Sivan Tumarkin, your partner in this firm, you guys have the very unique position as both an employment firm, an employment law firm, and insurance and injury law firm, which there's so much crossover between these two disciplines. I'm surprised that, frankly, more firms aren't bright enough to do it. But
Don't give them our secret. Don't give them our secret.
That's right. Sivan, welcome to the show. Want you to talk a little bit about what you do on your side of the firm, yeah?
Thanks, John. We do not just obviously employment law, but we deal with disability claims, primarily long-term disability claims, people who have applied for disability and have either been rejected by their long-term disability insurers or have received long-term disability and then were cut off prematurely. And we help them get the compensation that they deserve from the insurance companies.
So what happens, I guess, Lior, in a scenario like this is someone will come in with an issue with Sivan with long-term disability, and, it always happens. There ends up being an employment angle too, right?
There's always, almost always, John, this correlation between the disability issue and the employment issue. If your insurance company is going to cut you off and they say, we don't think you're disabled enough to be on a disability plan, well, the first thing that's going to happen is your employer is going to say, well, wait a second, we've just heard from the insurance company that you're able to come back to work, so come back to work. And in the meantime, you're sick, you're not able to work, and you're in a difficult situation. You're being cut off on the one hand by the insurance company, your employer is making threats against you. Very common scenario. Sivan and I deal with these issues every single day. And the nice thing is, when someone is in that difficult scenario, Sivan and I are able to help them on both fronts. Both dealing with the insurance company, Sivan and his team does that to make sure that benefits are reinstated or the compensation is given, and I can deal with their employer to make sure that, no, you're not going to terminate them, you're going to keep their job until they're better and ready to return to work.
And one of the things I did want to mention before we get to a phone call for both of you guys is that, and I've talked to Sivan about this so many times before, that once you call Sivan and get him involved with your long-term disability claim, the phone calls from the insurance company absolutely stop. And I think that's really important to expand on. You guys take care of it from then on, right?
Extremely important, absolutely. One of the greatest frustrations that people experience when dealing with insurance adjusters are the repeated phone calls, the emails. And people feel victimized by that.
Well, they're trying to get better.
They are, and insurance is supposed to be a safety net. Mm-hmm. And instead, they're feeling that they have to battle their illness or disability, whatever they're dealing with, and the insurance company. And as soon as we get involved, we are dealing with the insurance adjuster directly, the insurance company. The person can just focus on getting better, which is what they're supposed to be doing anyways.
Again, we've been doing the Employment Hour on radio for about 4.5 years in Ontario, and the number 1-855-821-5900. Anytime to call that number, get a hold of Sivan or Lior or someone else in the firm. And people call in, leave messages, and have questions as well. We'll get to one for both of you guys now.
I was diagnosed with cancer a while ago, and I applied for long-term disability through work so I can take time off to fight it. Last month, the insurance company cut me off, and a few days later, I was fired with no severance pay. I'm not really sure what I should do.
Wow, what a difficult situation. This is exactly what we were talking about. So I'm going to let Sivan in a minute talk about how to deal with the insurance company in this situation. But what I expect happen here, as I've said, is if the insurance company is saying you're cut off, the employer says, come back to work. And if you don't, then either you've resigned or we can terminate you for not coming into work. So let's make it very clear in terms of your employment. The only thing that you're required to give your employer in order for the employer to allow you to be off work is a note from your doctor saying you can't work. It doesn't matter if you're cut off by the insurance company. It doesn't matter if the insurance company believes you or does not believe you. If you're a doctor, the doctor treating you says, yes, you need to be off work to get better, and you provide that to your employer, they have to give you that time off. They can't question it. They can't say, well, we don't believe your doctor. They have to. So that may mean you may be off for a week, a month, a year, or longer. Now, you should be giving your employer updates, of course, while you're off. And if your employer terminates you, if your employer considers you to have resigned, that's illegal. That could also be a human rights violation. So I can't emphasize or overemphasize how wrong that would be. If that happens, you really do have to give us a call. And I'd like to know what you do on the insurance side. Yeah.
Yeah, and we do get these kinds of situations. They're very, very tragic, whether it's cancer or other types of illnesses. You know, the family's dealing with that. And here you have a situation where the insurance company just in a blasé manner cuts the person off. So their funding cuts off. Where are they going to get money to pay for their mortgage and for whatever else? And here's what people fail to understand, or they're under the misapprehension that, you know, you're battling this huge, gigantic company, this billion-dollar
thing, right?
Right. Now, important for people to understand, I used to work for insurance companies. I actually defended them. And here's the secret. They're not in the business of fighting claims. They're in the business of making money. And one of the ways they make money is they cut people off and they assume that people will not stand up for their rights, not understanding that as soon as you stand up for your rights, as soon as you come to us, for an example, and we start a legal claim, they will come to the table and they will pay you the money. I mean, not a week goes by without us in the office talking about settlements that we've been able to achieve for clients in various scenarios. Insurance companies don't want to fight these claims. It's not something that people need to be concerned about. The process is not difficult. The process is actually not that, it's not stressful because we're dealing with the claims process itself. People should not be victimized and not allow insurance companies to victimize them. That's the secret that the majority, that the public is simply unaware of, that insurance companies actually would like to pay you to go away.
You know, it's funny, the number that I guess reflects with both employment law and injury law is 2 years. I mean, you have 2 years to exercise your rights when it comes to your severance. And that 2-year mark, you've got to be careful about that when it comes to insurance and injury law too, right?
You do. You do. Although I'm sure that Lior has spoken about that before many times, there's no reason to wait. I mean, yes, you have those 2 years, but I'll tell you, if the insurance company cuts you off today, why would you wait 2 years? I mean, this is your money that they're holding on to. The sooner you come to us, and by the way, I should mention that oftentimes they don't cut you off now. They'll tell you that they're going to cut you off in a few weeks or a few months. And if you contact us now, we can many times intercede and intervene and avoid the cutoff, or at the very least position your case in such a way that a resolution is reached and the money's in your pocket without that gap of time where you don't have any money to spend, you know, to pay for your mortgage, for your kids' activities, for food, to put food on the table.
And again, it's so important to realize that both these gentlemen have this, they run the same firm. You do both employment law and injury law at the same time because there's so much crossover. Wanted to tell you briefly about, before we get to a phone call for both of you, the cutoff. You mentioned the cutoff, and you know they're going to invite you to appeal that cutoff. Quickly, what does that mean?
All right, so whenever you are denied long-term disability, or if you've received long-term disability and then you get cut off, what does that mean? You get a letter from the insurance company explaining their decision, why it is you're getting no more money or any money, and at the end there is usually a paragraph at the end of the letter that says you can appeal the decision. Right. What does that mean? It essentially means that you can ask us again, pretty please, can you reconsider? You are essentially re-asking the same people who cut you off in the first place. It doesn't work. I'm not going to say it never works, but I'll tell you that it's frustrating because people try it, they get delayed by months and months, they get denied again, then they get told again, appeal again. And by the time, they come to me, they've appealed once, twice, 3 times, they're tired. And then they come to me, and then within a very short period of time, we get them a settlement.
Right.
And they don't understand why. Well, because the system is geared to frustrate you and to make sure that you give up, because that means that the insurance company gets to keep the money.
And we'll go to wrongfuldismissalquestions.com. If you haven't used this website before, guys, you can simply ask a question. It will get answered within minutes. And you get literally hundreds of thousands since you've got this website going. I want to read one here. It says, can an employee who is recently disabled on an LTD but whose prognosis is uncertain be terminated, or is that grounds for wrongful dismissal? How much additional severance does an employee in that situation get?
Well, it's a great question, John. So if your prognosis is uncertain, it means you may be able to come back to work, you may not be able to come back to work. And an employer should not, under any circumstances, be making a decision about your future employment until that prognosis is certain. If you can't come back to work, that may mean the employer may be able to do something. If you are able to come back to work, then guess what? The employer has to keep your job open. So if your employer jumps the gun, if the employer says, well, we don't know if you're going to be able to come back to work, so you're gone, well, that's a human rights violation. That's illegal. They're letting you go because you're sick, because you have a medical condition. So not only are you owed severance, then you're owed potentially compensation under the Human Rights Code. Now, in terms of how much severance, again, we need to know the person's age, their position, the length of their employment. The longer you work, the older you are in the more senior position, the greater the entitlements. You can check out severancepaycalculator.com to find out how much you're owed. But if your employer lets you go in that situation, doesn't matter what the prognosis is, whether you're on disability or not, you have to give me a call. The law really comes down pretty hard on employers that do that, John.
Now, you mentioned prognosis. How about diagnosis? Which can they ask? Which can't they ask?
Well, let's first differentiate between the two. Prognosis has to do with timing, for example. How long are you going to be off work? What limitations you may have. So that's prognosis. Tell us what you need. Diagnosis, as hopefully most people understand, is different. Diagnosis is tell us what your medical condition is. An employer does not have a right to know your diagnosis. You do not have to tell your employer whether you're suffering from depression or a bad back. The only thing the employer is allowed to know, the prognosis, which is can you work, can you not work, when are you expected to be better, are you going to have any limitations? That's legitimate. But if the employer overreaches and wants to know specifically what treatment are you getting, what medication, what specialist are you seeing, what's the diagnosis? No, they're not allowed to know that. If they insist, that's again potentially a human rights violation. It can also be a constructive dismissal. You should not have to give your employer that type of private information.
TerminationQuestions.com is another option if you want to contact Lior at the firm and ask a question there. Quite simple one. What if my employer gives me an option to resign or be demoted? It's the old what if, right?
The old what if, John. So a resignation that's not voluntary is actually not a resignation. By definition, for you to resign, you have to make that decision voluntarily and unilaterally. No one can make that decision for you. No one can put a gun to your head and tell you resign or else. So if your employer says resign or else, and as a result you resign, that's a termination. You're owed full severance because the employer said you better resign or we're going to fire you, we're going to do something bad to you. That's not a real resignation. And we see that very often. The employer says, unless you resign, we're going to fire you. Well, at that point, the employer is the one that's decided that the employee is not going to work there anymore. So even though the employee says, fine, then I'll resign, that's not a resignation, not at all. So if your employer does tell you that, to resign or else, I think the answer should always be, I'll go with the or else. I'm not going to resign. But even if you do resign, that is a termination. You give me a call. I'll help you make sure that you get the severance that you're owed.
Now that we're going to wrap it up for this Saturday, contact is very simple. It is help@employmenthour.com, employmenthourtv.ca, 1-855-821-5900, anytime to get a hold of Lior or Sivan. Thank you very much for coming by the show today. The other half of the firm, of course, the insurance and injury law portion, they go hand in hand. You're going to need them both when it comes down to it, so make sure you call the guys. Next time, we'll join us right here in Employment Hour in 30 on Global.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.
Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com.